Hey, it's Dan Zimmerman. Welcome to Illustrate to Educate. Don't forget to subscribe for weekly objective videos on topics that matter. Have you ever wondered, what is the role of the United States Supreme Court? In this video, I'll cover the essential basics of the Supreme Court and its role in the United States government. Where did the Supreme Court come from? During the 1787 Constitutional Convention, delegates were debating separation of powers between the legislative and executive departments when they came up with the idea for a national judiciary, or a third branch of government. This was a new idea at the time, as judicial matters were usually handled by royal authority. Much of the role about the Supreme Court wasn't decided till later, but ideas about having a national judicial authority and its role for checking the executive's power to veto or revise laws were debated. In the end, the framers compromised by sketching only a general outline of the Supreme Court. 2 years later, the first United States Congress provided the detailed organization of the Supreme Court with the Judiciary Act of 1789. The Supreme Court was to be the country's highest judicial court and sit in the nation's capital. It would initially be composed of a Chief Justice and 5 Associate Justices. Immediately after signing the act into law, President George Washington nominated the 6 justices, and the Senate confirmed them on September 26, 1789. How has the Supreme Court evolved over time? The court's power and prestige grew substantially under Chief Justice John Marshall from 1801 to 1835. During his time, the court established the power of judicial review over acts of Congress. Judicial review is the ability of a court to examine and decide if a statute, treaty, or administrative regulation contradicts or violates the provisions of existing law, a state constitution, or ultimately the United States Constitution. This helps shape the balance of power between the federal government and the states. The size of the Supreme Court has also changed throughout time. As stated earlier, it started with 6 justices, and through acts of Congress has been altered anywhere up to 10 in 1863. In 1869, however, the Circuit Judges Act returned the number of justices to 9, where it has since remained. What is appointment and confirmation? Article 2, Section 2, Clause 2 of the United States Constitution empowers the President to nominate and, with the confirmation of the United States Senate, to appoint public officials, including justices of the Supreme Court. This clause is one example of the system of checks and balances inherent in the Constitution. The President has the power to nominate, while the Senate possesses the power to reject or confirm the nominee. The Constitution sets no qualifications for service as a justice, thus the President may nominate anyone to serve, and the Senate may not set any qualifications or otherwise limit who the President can choose. Once the Senate confirms a nomination, the President must prepare and sign a commission to which the seal of the Department of Justice must be affixed before the new justice can take office. According to the Congressional Research Service, the average number of days from nomination to final Senate vote since 1975 is 67 days. How long do members of the Supreme Court serve for? This is also called tenure. The Constitution provides that justices shall hold their offices during good behavior. The term good behavior is understood to mean that justices may serve for the remainder of their lives, unless they are impeached and convicted by Congress, resign, or retire. Because justices have indefinite tenure, timing of vacancies can be unpredictable. At times, justices have retired within weeks of each other, while in other cases it's been up to 11 years. Despite the variability, all but 4 presidents have been able to appoint at least 1 justice. What does the Supreme Court actually do? The court receives about 7,000 petitions every year, but the justices only choose about 100 to 120 cases by writ of certiorari in order to send up a case from a lower court. Typically, the justices discuss any cases one of them has recommended from earlier readings. The rule of 4 governs their choices. If 4 of the justices vote to hear a case, all 9 agree to it. How do they choose their cases? Generally, the court considers only cases that have far-reaching implications beyond the 2 parties involved in the dispute. For example, a case involving privacy rights of students in public schools, or cases in which 2 lower courts have reached conflicting decisions, and any case that contradicts earlier Supreme Court decisions. Now let's talk about hearing and deciding on a case. Hearings begin in October every year, and the last cases are usually heard in June. The justices receive briefs, or summaries of arguments from the lawyers ahead of time. Often they receive amici curiae, or briefs prepared by interest groups or government agencies that support one side. The hearings are open to the public and are strictly timed. Each side has about 30 minutes to present its case, and the justices typically ask questions and even debate one another during the allotted time. After the public hearing, the justices meet together privately to discuss the case. They share their opinions, debate the issues, and eventually come to a conclusion. Each justice takes a side individually, and because there are 9 justices, one side always wins. How does the Supreme Court announce a decision? When the court announces a decision, the individual justices' opinions are revealed. A unanimous decision, 9-0, indicates that the justices were in total agreement. This vote is rare because the cases that have been chosen are the tough ones. Decisions are usually split 6-3, 7-2, or 5-4. Along with the decisions, the justices release explanations for each side. A majority opinion is prepared, usually by the senior justice on that side, and the justices whose point of view did not win release a different opinion. Lastly, how does the Supreme Court implement a decision? The power of the court to implement its decisions is limited. For example, in the famous 1954 case, Brown v. Board of Education of Topeka, the justices ruled that racial segregation in public places is unconstitutional. But it took many years for the school districts to desegregate. The court has no means, such as an army, to carry out their decision. Instead, it must count on the executive and legislative branches to back its decisions. Despite that limitation, the justices often set policies that lead to real social change. So even though justices don't do a great deal of their work in public, they have real power in the American political system. Did you enjoy this video about the Supreme Court? Hopefully it gave you a good introduction about the role of the Supreme Court in the United States government. Please like and share the video, subscribe to Illustrate to Educate, and comment on your thoughts about the Supreme Court. And don't forget to check out some of my other videos to the right.